Welcome to Blueprint for a New Reality. It's a webinar of current events and things all trending in the roofing industry. Today, our topic is litigation, claim law for the new reality, and we've got a special guest, David Furtado with Furtado Law Solutions. Let's go ahead and introduce our panelists, and then we'll get to David and hear a little bit about what you do, okay? Nathan, you want to start?
Hi, I'm Nathan Higgs. I'm the director for Labor Connect. We help companies with getting labor for their project, as well as ordering material in the corrected quantities, and making sure that everything is to the job site properly and with the proper waste.
Jeff Wisniewski.
Hi, I'm Jeff Wisniewski. I'm the president and founder of GiddyUp. We're a CRM software that has an integrated canvasser, material ordering, takes you all the way from canvassing all the way through the job.
Bill.
Bill Higgs, sales manager for Labor Connect.
William, you're back with us this week.
I'm William. I'm the general manager of production with Labor Connect.
And we've got John back as well.
Hey, how you doing? John DeRosa with SRS Distribution. I'm the director of contractor training. So if there's everything I can do for you guys to help you sell more and make more money, give me a call.
Great. And Jason, we're not going to forget you again this week. You're muted, bud.
You're muted, Jason.
Got it. Jason Sloan with Furtado Law Solutions. I'm the business development specialist. So any questions you have as far as our processes, I can go through that with you guys.
All right. And our special guest, David Furtado.
Well, how are you doing? I'm David Furtado. Once again, I'm principal of Furtado Law Solutions. I litigate the cases for the company and ensure that contracts are paid properly for the work that they're doing.
Oh, the fellas have a series of questions. We're kind of just going to shoot them off, let it flow. We don't really have any rhyme or reason, so feel free to throw out those questions the way that we did last week, or we can pull some off of online if we're actually going to remain online. So, Bill, do you want to start?
Sure. David, having having worked in supplements quite a bit over the years, I'm curious, and something I've never actually had lined out for me, is what is a good job for litigation, and is there really a minimum qualification for litigation?
No, because I get that question a lot about I kicked my computer, about the minimum for litigation. And I don't believe there is, because all the cases are the same issue. And what I see the carriers doing is the carriers chip away at little things like, oh, they'll take away a little bit here and a little bit there, and no one litigates those issues. But if no one litigates those issues against the carrier, before you know it, those issues what they take away from the estimate gets bigger and bigger and bigger. So what I like to see, and what I think the solutions companies really does a really good job at this, is what we're able to do is explain to the carrier why our contractor deserves to be paid on something. And many times in litigation I've seen is that you see basically number slinging. The contractor wants X, the carrier wants to pay Y. They sling numbers back and forth, but no one ever explains or takes the next step of saying why the carrier is mistaken in their belief and why the contracts are correct in their belief. So that's what we preach, Jason and myself preach to people when we talk to the contractor is, please explain to us why your labor rate on this job in this town was this much money. And we're able to then communicate that to the claims adjuster, and we have the right experts we rely upon to make sure that message is succinct and clear.
Very good. Thank you.
You're welcome. Any other questions?
You're muted.
William, you've been in the industry, and you had some questions regarding when is the right time? When do you go to litigation?
So my question, I've been on production and I've been in sales. I've done pretty much everything on that, but I guess more for like new sales guys. My question, David, would be more like, with the insurance claim process, like what are your feelings with supplements, with public adjusters, with lawyers? Like where does all that kind of tie in? And specifically, when do you feel like how often should it be used, and where do people start? Because that's a confusing thing as a salesman when you hear about, oh, use a supplement, or oh, send it to an attorney. You got fees, and everyone starts panicking about their money.
About fees, exactly. I would say that the attorney is the last resort. And that's what the idea of creating the solutions company, I created with Kyle Larson and Jason Sloan. And the idea was to give the industry not an inexpensive, it is inexpensive, but to some people it's not, a more efficient, inexpensive way of supplementing a claim. So for instance, if you're the sales guy and you're selling a roof and you're having a hard time with the carrier, and I believe you take a few runs to the carrier as a sales guy, you should, right? You want to get as much money as possible before you have to pay my company to help you out.
Of course.
Like in other words, you put it in your head. Like in other words, say, give it 90 days, 60 days. You have to have a goal in your head of when you're going to be done running at the company, right? So the first thing we do is we take your file and we then ask a bunch of questions of the salesperson or the principal, whoever's doing the claim for the roofing company or the contractor. And we then put a package together to the insurer and we take a few runs at it. But for instance, we're pretty successful in getting things paid because we're able to argue the legal reasons of why someone owes money. Because I'm an attorney, I sign up on the letter. So I look at every file and I'll explain a legal reason. So if you're going to litigation with a solutions company, it's your last resort. And how I put it to clients then is if we've supplemented it for you and you've gotten paid, that's what happens most of the time. People get paid what they want. And the fees much less than going across the litigation. But if you're in litigation, you're getting money that you're never going to get unless you get to litigation. So the answer to your question is that you shouldn't be in litigation unless you're getting money you absolutely cannot get without being in litigation. And once you're in litigation with, say, an assignment of claim, in many states, if the company was delaying benefit, like I practice in California and Colorado mostly, California's bad faith law is reasonableness. So is Colorado's delay and denial statute, reasonable behavior. The solutions company, what it does, it lays a foundation to give the insurance company every opportunity to pay the claim. That's what we're trying to do. And if they then don't pay the claim is in a good position. So when it is filed and say litigation counsel for the insurance company gets involved, if it is filed, they'll pay it quickly. And if they don't pay it quickly, we then have it in a position where the contractor can recover the legal fees during the litigation process because we'll get more damages than what the claim was. So if we supplemented it, say 3 or 4 times, we have communications. I write letters. Of course, I'm a letter writer. I like to write. I don't call people names in my letters. I tell them why they're mistaken. That's the one thing people do. They get emotional and they get angry. I had a conference this morning, which I missed my meeting with Jason this morning for a conference. I'm with a client, and there's some bad emails in there with a public adjuster and between the publisher and the client. Those are discoverable. So I always tell people, don't call people names. Like if you disagree with someone, try to educate them. Educate the adjuster as to why he's wrong or she's wrong. And many times she or he being incorrect, they have no authority to change their mind. So what you want to do is you want to give them every reason to change their mind so it goes up a level of management. And if you can't do that, you want to be able to then in litigation explain to a jury or a fact finder, or maybe it could be a mediator, why your contractor and client now deserves damages, which in Colorado on a breach would be double damages in the breach amount, and plus attorney's fees and costs. But to get there, you have to at least tell the mediator, sell to a jury, because you're selling, even as a lawyer, you're selling to a jury, why what the carrier did was incorrect. And that's what the solutions company does. It gives the carriers reasons to pay. We're not here to fight with the carriers. We don't fight with them. We give them reasons to pay, and then if we have to fight, we allow the judge to do that for us. That's what we have judges for. And I tell the contractors all the time, we're successful because we set the claim up correctly to allow the company to pay. That's what we do. Because let's face the facts, no contractor, no salesperson wants to be in litigation. The named insured doesn't want to be there. It's not putting a roof on their house. It's not fixing their hail loss, their fire loss, their water loss. No one wants that, and we don't want that. But if the message to the carrier is we don't want that because it's not helping anyone, including the carrier, what we want is the right result. And if we have to do that, then that message was sent loud and clear before the litigation, so the contractor, the salesperson, the principals are happy with the result. So
I want to encourage the viewers, now that we've managed to stay live today, I can see questions coming in, so please shoot questions in for David, and in the meantime, we'll just continue with the panel. Jason, since you missed your meeting with David today, do you have any questions for him?
We talked about this the other day, David. What are the do's and don'ts on advertising? So, we talked about stuff comes out in litigation that's in advertising and contractors are getting in trouble. And so can you go into that a little bit?
You want to ensure as a contractor that your advertising is not stating or hinting that you basically practice public adjusting a law. So, for instance, we see these advertising, like we don't like to see things like, we'll get you every penny we can get you from the insurance company. That looks odd to a jury, right? So a lot of times in advertising, we're using puffery. We're just trying to make ourselves look better because we want to land the client. You can do that without crossing any lines. So as one of the things we do at the solutions company to help the contractors out, if you have ad copy, we'll look at it for you. I do that. I'll say, hey, you might want to tone this language down. I had someone send me I can't say what it is because it's attorney-client privilege, but he wanted to use this tagline, and I had to look at it and tell him you can't use that tagline because the tagline hinted that he was a public adjuster. He's not, he's a contractor. And what we do is we work together to develop a tagline for him that he was satisfied with that wasn't crossing the line with a public adjuster. These things don't matter 99 times out of 100 unless you're in litigation, and then defense counsel nitpicks at this kind of stuff. That's how they win. They win by pointing out things that I call rabbit trails that have nothing to do with whether or not they owe drip edge or sheathing or the right roofing shingle if it's damaged by hail. Once they lose that battle in litigation, the battle then is, oh, was your client's advertising perfect? And I know it sounds ridiculous to people, but that's how naysayers win. On our side of the equation, we're trying to build something. We're trying to fix a problem. We're trying to fix a house. We're trying to make an insured whole. We're also trying to make money doing that, and that's allowed. We're allowed to make money doing that for people. That's how we stay in business, to help more people. And that's what we do. It's hard to do that. It's hard to keep the insured satisfied and everyone happy. On the other side, their job's a lot easier than our job. Their job's a lot easier than our job. What they do is they point out, oh, you see his website or her website, and they said this, that means they're a public adjuster. Judges don't even care half the time. Maybe the jury doesn't care. But every once in a while, they'll get something like that, and they'll hook into it, and they'll say you're doing the unauthorized practice of public adjusting, and they're using it to basically bully you into a settlement because you're afraid to go further because a jury might think poor of that or a judge might think poor of that. So what we offer is we look at people's advertising to see if it's legally within bounds, meaning that you're not advertising legal services or public adjusting services. And we do that because we want to help you guys. And if you give us a claim, we don't want the thing to blow up. And we're trying to get you paid, if we couldn't get you paid in the solutions process, over a tagline you used, not knowing any better. Because no one in the industry we help is trying to commit crimes. All they're trying to do is sell some roofs, sell people on things, and sometimes they'll say something that's a little bit gray, and we try to bring it into the white part, away from the gray. That's what we do. Because if it's gray, the other side tries to bring it to the black, and I don't want to have to fight over what's white or black. I want to have to, let's bring it to the white in the beginning, as opposed to the black, being that's what the gray lead should be doing, and then the whole focus of the case gets switched to a tagline on someone's shirt advertising their company, and we want to avoid that.
And that brings up a question I have for you, David. Everybody has contracts, right? Consulting agreements, contracts, contingency agreements, however they want to word them, right? Each state has a different word that you can use, but ultimately it's just a contract between you and the homeowner as a contractor, okay? In certain states, they allow AOB, assignment of benefits. In certain states, they allow AOC, which is assignment of claim. You've got to have the correct verbiage in there, in your agreement, to make sure that you have the best ability to, facilitate that if that ever goes in front of a judge. Do you recommend, having a separate AOB addendum to their agreement to make sure that it is clear and precise? Or do you recommend having the AOB or AOC on their agreement that is actually their form fill? So, every contract that they go out has AOB or AOC compared to only the ones that you feel you need to do an addendum to. I would like to know that, what your thought on that is.
Well, my thought's a legal thought, not a business thought, because many times you to have the AOB. Well, let's use AOB and AOC interchangeably for the conversation, because some states allow, which one.
Sure.
So my feeling when you're in litigation is you want a separate form that's an assignment of claim form, assignment benefit form, because not every claim you need an assignment benefit.
Correct.
And I truly believe that if you explain to a homeowner, a building owner, property owner, why they need an AOB or an AOC, because you're helping their interest, they'll sign it. And you want them to acquiesce into signing it. I can give you guys example after example. I'm in an appeal right now which we're appealing the sheathing ruling, that a judge didn't believe that if sheathing was directly physically damaged by hail balls, that it should be replaced by the insurance company. Bizarre. So we had to appeal that to the Court of Appeals. But there was another issue in that case, and the issue was whether or not the client's assignment of claim form was valid under the law if they had the assignment. So the Court of Appeals came down and asked for supplemental briefing on whether or not I had the right party in interest as the plaintiff. And we're talking obscure language in this thing that I didn't draft, by the way, as a disclaimer. We draft them for our clients. We'll give you a free one. We have it. We actually, my law firm hired another law firm. It's a defense law firm that drafted our roofing contract, our general contractor contract, and our assignment of claim is on benefit contract. So they're perfect under the language. This roofing company made the mistake of doing, they go online, they cut and paste, and they might lose an entire claim because of language in this AOC or AOB that doesn't really mean anything. It's technical.
Sure.
So the very technical thing. So the roofers will tell me, and I apologize if you guys aren't all roofers. I know you're not a roofer, so let's use contractors, a better term. Contractors will tell me, oh, David, it's so much faster to do this. I always tell them not everything good goes fast.
Correct.
Think, and if the homeowner is asked, because by the way, they all get deposed. Remember I was saying about earlier how they just poke pop shots out of case of pheasant counsel? They all depose the homeowner, right?
Right.
The first question they ask the homeowner is, did you know you were signing? And wouldn't you love to have the answer be, yeah, I knew I would have signing. I wanted to give these fine people my benefits and my claim because they do all the work for me. I want to make sure they pay property. I want my properly fixed property. I want that answer as opposed to you're slipping bullets thinking, oh my God, what's he going to say?
Right.
I don't want that. And that's, I always tell people, it's always good to go slow. Everyone that's our client has plenty of business. They're all good at their jobs. And if the homeowner trusts you and you explain the assignment of benefit form, the assignment of claim form to them, they will sign it because they don't want to be involved in it. And then I can help you because if you're a client of mine, I'll help you with the homeowner and say, listen, this is the reason why they're doing it. They take all the mystique out of it. They've been doing the claim. They want to make sure they pay properly for the work they're doing. There's additional work that needs to be done, or they put money out of their pocket to do the work so it was done properly. And they'll sign. And reasonable people, which most of us all are in society, will sign it.
It's all about how you present it. We did just under 4,000 contracts when I had my roofing company, and I would say 40% of them had AOB or AOC attached to them, depending on the individual state. And we did them as separate forms, and that's the reason I asked. Is my attorney recommended separate forms, and you'd be surprised. It's all about how you approach it with the homeowner, explaining it to them. What I feel the biggest disconnect is the sales rep for the roofing company or contracting company. They get excited and they're afraid that they're going to talk themselves out of going, hey, here's another form and here's another form. It's all about presentation, how you present it. And that's the piece that, is something we're happy to help train on. I'm sure you're happy to, give 10, 15 minutes of your time to a company, explain the reasons of this. But I really think that that's what it boils down to. And that's the great thing about, if we can turn what we're experiencing today in the environment into something good. It's that we have time to train now. We have time to explain and mentor the guys that we, in last year time situation, here's contracts, go out and get them filled out. Here's business cards, go get them filled out. Now you can sit down and actually train a sales staff, encourage your sales staff, and explain to them the proper tools that are necessary to build your company to be the best company in that market. And I think that's the big thing that is my takeaway from, if we can turn what we're experiencing now into good. And I truly think, with SRS, John doing, his part with the contractors, us doing our part, Furtado doing their part, I think that's really where this comes down to. And, GiddyUp has a wonderful tool that will allow you to, store all those agreements in a specific place, in a vault or whatever you want to call it. I call it a vault, but, so that you've got that documentation if you ever have to go to court. Here's my whole file. Here's the whole file on this customer's, documents. Here's the AOB. Here's the AOC. Here's the contract. Here's the addendums. All that. And, so many roofing companies and contracting companies falter in documentation. I've worked for dozens. Jason and I have worked for a few together. I've owned a few. Even the ones I owned, we faltered a lot of times because you get to going so fast that you can't keep track. And so it's, hustle, hustle, hustle. We'll figure it out. And that's when mistakes happen. And so process. And,
I want to jump in. We've got 6
we're almost
more
out of time.
things, and
I'm
I want to
sorry.
get John
I
and
went
Jeff.
off on a tangent. Sorry, guys.
So I want to kind of tag on to what Nathan was saying. As the only software provider on here, we're constantly getting asked, and we're getting involved more and more. We're really a workflow management system, and we're constantly going through and being asked, how do we manage that legal workflow in the tool, in the process? So we're doing more and more workflow design with our clients as far as what point do you turn this into a legal workflow. And I guess what I'd ask you is, do you have any hints or tips that you can give? As Nathan pointed out, we can track documents and have that inside the system. That's one thing, that's easy. Having that workflow where the contractor and the attorney are in sync and can share those views is the next best level. And I guess what I'm looking for is, what advice do you have that can help contractors document and build up their case as they're going day by day, so that it's not a big issue once it hits your desk?
Well, you have a CRM system, right?
We
Yes.
do. Correct.
Okay. That's excellent, because I many times what you see is the contractor, say they're out in the field, they're talking to the adjuster, talking to the homeowner. They need to use a good CRM system to document what they did and when they did it, because that's why it's a timeline. So say the solutions company gets it, we supplement it, we get the contractor some of what they want, but not all what they want. The contractor wants to collect the rest of what they need, and we go to litigation. How I create the timeline is I use a CRM system. So I see when the contractor talked to the homeowner, when he had the contract signed, when he had the AOB or AOC signed, when he spoke to the insurance company, how often. And if you have a good diary system on that CRM process, it will remind the contractor or the company who is handling it to call the adjuster. And then you document what you're talking about in the system, so I can put in my complaint on this certain date at this certain time. This person spoke to the claims adjuster, and this is the information they gave them. See, at Furtado Solutions, we have a CRM system, and it's very important we utilize that. So if it has to go to litigation, that's my timeline. Memories don't work. Like the comments that Nathan was making were perfect. Training, process. If the CRM system is part of that process, it makes my life easy, because if I'm talking to Nathan or one of his guys 6 months after he did something, they're not going to remember on, March 14th this happened. Like, for instance, when did Governor Polis shut us down and give us shelter in place? So I remember the exact date in Colorado. You forget. Everyone thinks we've been sheltered now for like 5 months, it feels like, right? And But look how fast we're losing time. I mean, everyone was going nuts after like just a week and a half of this, and
Right.
that's an exact example. It's something that's affecting us now, and you can't even remember the date that governors or mayors or whoever state, and they signed orders, right? I have to go online because I'm filing these business interruption insurance claims when these people were shut down because of the civil order. I have to go online. Okay, when the mayor of LA do this? When the mayor of Santa Barbara do this? When the mayor of Denver do this, right? I don't remember. So I go online, then I save a document and I have a system, right? So like your CRM system is a very important tool because without that CRM system, they're not writing anything down. Like that's my biggest complaint at my law firm all the time with an associate or worker here, or it's a solutions company is, wait a minute, when did this happen? When? And what was said? Because you can't make it up. And in the complaint, if you have a good CRM system, I can cut and paste from a specialty. I can just copy it. It makes my time a lot quicker. I can do a lot more for my clients. And it's accurate when they ask the client deposition, how do you know fact number 7 in that complaint? Oh, it's in the CRM system. We write everything down.
So David, what we've found is obviously all of our clients love going through and documenting. The minute they hang up, they're right on that CRM. They're noting everything, right? And I'm saying that obviously tongue in cheek because I don't think any contractor lives and dies and loves using the CRM, right? It's a necessity. And what we've seen is that when it becomes an issue, it's unfortunate because when it does become an issue is where it's hard. And I guess, trying to find that balance where, we do everything we can to make it as easy as we can for them to document and build those trails. But, do you have any advice, like as you're going through, at what point does your radar go up to say, boy, now we need to be kicking it into high gear?
Well, does your system work on a phone?
Yes, it does.
Well, there's no excuse then. I
Right.
mean, I think it's high gear all the time. What Nathan said, about training and processes, like law, for instance, right? I have someone that overlooks me. It's called the judges, the Supreme Court. We have monitoring, right? If the first thing, say I was in a dispute with a client about what was said or done, and we're in litigation over it, right? Which has never happened in my career, but this is the one I'm always in high gear. Because if there's a dispute over what was said or done, I can pull up a document, a diary, whatever it may be. So although I know everyone can't stand document, oh my God, I'm too busy on Facebook. I'm too busy tweeting about what the president just said, right? If it's on the phone, they can just leave the person's house so they can do it as they're talking to someone. Just the perfect note. It could be in shorthand, like a bunch of codes, right? And I know what I know what you're saying about the software program is that people will buy it and they don't use it properly. And I think it goes back to what Nathan said, process, learn the software. I have the same problem with the law firm when it comes to inputting stuff with new associates. They don't understand, sometimes they don't understand the importance of documenting things in our program called Firm Central or at the Furtado Solutions Company. The points that document our CRM, how are we supposed to be supplementing for you guys if we're not documenting our own CRM? Come on, it's a pain for all of us to sit down and type things up. But think about the old school. I mean, it's on phones. You don't have to go back to your office, go to your computer. It's right on your phone. So there's no excuse for it. So I say this: if they're not in high gear all the time, that not in high gear is going to ruin a bunch of their claims, and it's going to cost them 1,000 times more than the time they would spend on the CRM or the cost of the program. They'll regret it. So it's the
David,
best.
I just want to jump in. We are at time, but we're going to go a little long. We still have a question from John, and then we'll wrap it up and see if there are any other questions or anything else that you want to bring out. John, do you want to ask your question?
John's coming off mute.
Sorry about that. Yeah, I just, I think all this information is really great, but I just love for maybe to just give us an overview of what type of services you provide.
My company?
Yeah.
Oh, okay. All we do is first party insurance property law. That's what we do. So the solutions company, the service provider that contracts the industry, is to ensure that when we're doing supplemental services to get people paid properly, to ensure that it's done properly, it's documented properly, we have the right systems in place to get them paid. That's the first service we provide. The second service we provide, if that's not done, is we go into litigation to make sure the contractor gets paid. And of course, in supplemental those two services, we review contracts for contractors, their advertising, their slogans, whatever they're putting out in the universe as on a website, to make sure that when we're in litigation or supplementing their stuff, because you'd be shocked by this. If we supplement for a contractor, the adjuster always looks them up online, always. And they'll make little comments like, oh, they're practicing as a public adjuster, and cite some obscure statute that the roof doesn't even know about, that of course everyone else knows about because the roof is trying to busy selling roofs. So that's the service we offer. We make sure that they're legally compliant with the state's laws when it comes to advertising, what they can say. We make sure that contracts are compliant. We can provide those for free. Their AOB and AOCs are compliant. We provide those for free. And then when it comes to the supplemental of the litigation, we make sure they get paid because we provide expert services because we know what we're doing. The people that work with us know contracting. They know what the contractors need. In fact, a lot of them are former contractors, and they know roofing, and they know siding, gutters, they know the trades, GC, O&P. And it's also, we step out of the box. Stop arguing Xactimate 10 and 10 GC, O&P. Stop. There's other ways of getting that done. So if you do that, and we get the solutions company has it, we take that out of the box to get the proper margin by using economics. Because I'm going to tell you guys something to be shocked. There's no insurance company standard when the insurance company is the one setting the standard. Think about that. If they're setting the standard, why would they pay anything? They'll say, look at GCO&P, and you guys know this. That standard changes all the time. 3 trades, complexity of trades, coordination of trades, complex trades, right? How about argue this? Proper margin to keep a company in business, right? So that's what we do. So we're able to argue legally margin and standards as opposed to what a contractor, because they can't argue that. We can. And we have experts in our corral of experts that will tell a jury why they have to make a margin that they're claiming on their Xactimate. You know, I had a case in litigation recently where the attorneys told me that all a contractor can make is 10 and 10. That's it. That was their position because that's what Xactimate says. And we all know that's not true. You know, GC making 10 and 10 is called the bankrupt GC.
Yep.
Fellas, do you have any other questions for David?
How can everybody get a hold of you, David?
Well, Jason, they can contact you. We have a website, furtadosolutions.com. We have furtadolaw.com. And of course, our telephone number is 303-755-2929. And my personal cellular number is 303-710-9526. Thank you all.
Thank you.
Thank you.
Thanks,
Thanks, fellas.
Dave.